Welcome back. We are live now. Welcome to the Mission Mediation podcast produced by The Pact. My name is Jonathan, and together with my co host today, Nishant, both partners at Pact, we welcome you to the second episode of the Mission Mediation podcast. Once again, touching upon that very provocative topic: are mediators actually mediating? All right, I know it was meant to provoke. Last time we had some fantastic conversations with Bill Marsh and Chitra Narayan, and of course today we're joined by two fantastic guests once again. Before I get down to introducing them, just a little bit of an introduction to the Pact. We've spent the last 8 to 10 years working with around 16,000 young lawyers, acquainting them with the knowledge and skills of mediation. Created various platforms, conferences, trainings, awards, competitions for aspiring lawyers to understand what mediation is all about and rub shoulders with some professionals in the field. We've been also developing conversations about the marketing and branding and the business of mediation in India. Over the last 3-4 years, we have focused all that down on mediation advocacy, which is the role of a lawyer in a mediation setting. And we've had the privilege to work with the dozens of lawyers in the chamber practice, corporate world, in the disputes practice, in-house counsels, acquainting with them with their role in the mediation setting. Today's focus, though, is on the mediator. Are mediators actually mediating? We have thousands of mediators trained in India and thousands more trained across the globe. But it's not easy to build and sustain that practice as a mediator. Most of us know that. So most mediators, especially in India, are sustained by court and next mediation centers. And we're going to dive deeper into how we can actually talk about those things that can make actually a mediation career. How do we develop it? How do we sustain it? How do we market it? Especially with India now on the cusp of the Mediation Act finally coming into force. There's a lot of excitement about that, but how do we actually make this into a profession? And that's the practical reality today. Hopefully starting today and inspired by our speakers, we'll have more people talking about it. We have to talk about it. We can't be shy about talking about how we build a profession about mediation. We've got two fantastic mediators joining us today, two of the finest mediators across the globe. We've got Nadia Alexander and JP Singh joining us today. If I start introducing them, I'll need a whole hour for that. So forgive me that I'm going to keep it really, really short. Because when Nishant and me said that we're going to put this podcast together, we said, let's invite our friends and let's have a conversation about mediation. So this is all about that. But very quickly, JP Sir is a well-known civil, commercial, and arbitration lawyer. He's also an accomplished mediator. He's a founder, organizing secretary of Samadhan, the Delhi High Court Mediation Center, and is the current president-elect of Mediating, International Council for Conflict Resolution. He's a former vice president of the Delhi High Court Bar Association, and of course, a recipient of the National Impact Award in Mediation. JP Sir, thank you so much for joining us on a busy Saturday in Delhi, by the way. They've got the elections around the corner, or the counting of the votes, actually. Next, I want to introduce you to Nadia Alexander, who's a professor of law at the Singapore Management University, where she teaches professional mediation skills, international mediation law and practice, and cross-border mediation professional skills and practice. She's the director of the Singapore International Dispute Resolution Academy, also known as SIDRA. She's an accredited mediator at the SIMC HKMMAL, the Australian National Mediation Scheme. She was the director and board member at the Singapore International Mediation Institute and a senior fellow at the Dispute Resolution Institute, Mitchell Hamlin Law School in the United States. Nadia, thank you so much for joining us all the way from Australia. Perfect. So those are the quick introductions. For those of you who don't know JP Sir and Nadia well, you should be going and checking out their work on Google. I'm going to be putting on some more information at the bottom of your screen. So you'll see those tickers going from left to right or right to left on your screen, and you'll learn more about what we're doing at the Pact and also about JP Singh and Nadia Alexander. But before I hand it over to Nishant, who's going to take us into this very interesting segment of breaking down some recent mediations that have inspired our speakers, a quick shout out to everyone who's joining us live, wherever you're joining us from. We had around 1,200 people who signed up for this. So thank you so much, first of all. Say hello on LinkedIn. Tell us where you're joining us from. And if you have any questions, any comments for any of the speakers today, please put that in the comment section. We'll try and take that up as well. So once again, feel free to participate. This is your forum. All right. On that note, a very quick question to both Nadia and JP, sir, before we get into the case studies. A quick provocative question. Are mediators actually mediating?
You should answer first. JP.
Nadia, I think the ladies first.
So my quick answer is yes, and not always in the narrow sense of the word. So legal referral, court referral, half-day, one-day mediation. And one small example, a couple of decades ago, I was asked by government authorities to go into a hospital to mediate. And the short version is when I arrived, they said, we don't want mediation. Right? And I said, tell me why. And they said, well, because it's legal. It's very legalistic. We don't want a legal process, because they associated it with the courts so much, right? And so then I said, well, is there another way I can help you? Do you want to have a conversation? Do you want someone to facilitate? Anyway, I ended up facilitating their conversation, confidentially, of course. For me, that was mediating, right? And I think there are many, many people today, accredited mediators, who are also doing that sort of work. And so, yes, mediators are mediators. Yeah.
It doesn't have to be a straightforward kind of, when we talk about mediation, we think it has to be something that's either referred from the code, or it has to be something that's already, where lawyers are already considering a litigation battle. And I really want to get down to those. And I know you have a fantastic example for us as well, Nadia, that you're going to talk to us about in terms of mediation practice. I'm really looking forward to that. JP, sir, a quick response to that question.
Yes, Jonathan, so far as India is concerned, mediation really took off after Section 89 was amended in 2002. And the first mediation center was set up in 2006. Well, whenever it starts as a court-annexed experiment, the standardized mediation, training course that courts accept is basically which tends to focus in the direction of a settlement-driven model. And once we are talking about a settlement-driven model, then, there are allegations of pushing, coercing, cajoling parties to settle. And that's the biggest, bane so far as I'm seeing in the mediation movement when India took, what took off in India. Because what it focuses on is the beautiful part, of mediation, which is transformation. And we miss out on that richness and the variation that is present in mediation when we are only looking at settlement. Yes, settlements are happening. I mean, at the Delhi High Court Center today, more than 56% matters at the level of the High Court are getting resolved. So therefore, mediation is taking off. But, my answer to this question largely will depend on the context and the mediator's adherence to core principles of neutrality, facilitation, and voluntary resolution. If these are upheld, then mediators are indeed actually mediating, providing a necessary service for conflict resolution. That's my first take on it.
So positive take once again of India. We know we have our challenges there, but once again, you have the stats, you have the fact that there are that many mediations. I know I visited you at the Samadhan Mediation Center, and you're always busy mediating every afternoon. So we know that for a fact. That's true, that mediators are actually mediating. So thanks once again, Nadia, JP sir, for those quick initial thoughts. I'm going to hand it over to Nishant to lead us into the next segment now.
Thanks, Jonathan. And I completely agree with JP sir, because in his answer itself, he's moved away from the settlement percentages. A lot of people, when we ask them, hey, are mediators actually mediating? So they end up saying, they end up looking at it in terms of the number of cases or matters that they've settled, whereas, JP sir put those points down, which is actually driving away from the context of just settlement. So on that note, JP sir, would like to ask you about a mediation case that you were a part of, that you mediated, that you found challenging, and would love to break it down, because as we all know, due to confidentiality, a lot of mediation matters that do take place do not come out in the open. But the idea of having this section is basically to say, hey, mediation is happening, of course, within the realm of confidentiality, whatever we can divulge. But it'll be great to know about a mediation that you're a part of, that you found challenging, interesting, and would love to break it down.
One of the matters which I really found very challenging was fight between the siblings. The father expired and left a huge estate, and leaving behind the mother. Mother was with the son and daughter on one side. And so issue the first thing that I see, the difficult part in a mediations setup, is actually building up trust. That's the biggest requirement when it comes to mediation. And how I got over it. One of the family members, who is also a trained mediator, whom the parties trusted, first initially sat with the parties and build the background. Then she brought me in as a trained mediator who was doing specially family disputes and property issues. And so that respect, first, the trust was built by the relative, who's a trained mediator herself. But then she needed somebody whom the parties could build trust on as the process person who specialized in the process. And so then both of us actually sat down and mediated in that particular matter. And ultimately, the matter did get resolved. And but see, the important part that I've seen, the biggest challenge that you face when it comes to settlement of mediation disputes, is you may arrive at principally a settlement, but writing up a settlement, drawing up a settlement, and then ultimately how you go through the process of implementing steps, because there's so much of lack of trust that parties, even if they settle, at each step, they are still distrusting each other, whether the other party, if for example one party executed documents which were to go to the other side, they were kept in escrow with us, and they were very clear, these documents will only be handed over if they comply with this part of the settlement. So we had fixed the timelines. Question was timelines, that one party said, look, if I go through this, will I get these documents from the other side? So even when you arrive at a settlement, the biggest challenge that I find in India, especially when you talk about family disputes or commercial matters, where parties have to take various steps for purposes of implementation of the settlement, is lack of trust. And that's where the biggest role, the biggest challenge that mediators face, because they are not willing to budge, they are not willing to hand over documents, they are not willing to go ahead with the settlement unless they are assured that they will get what has been agreed finally. And so therefore, getting first to the step of settlement, and then drawing up the settlement, drawing up timelines, and ultimately going through with the settlement, and till the final stage of implementation. So lawyers or the mediator's role doesn't end while the settlement is drawn up or parties ultimately reach the settlement. Your role also continues till the settlement actually gets really implemented. And so therefore, that's the biggest challenge that I find so far as mediations that I've done, is final outcome, final settlement, final ultimately resolution which gets implemented. Implementation of a settlement is the most important part.
So JP sir, when you know that there is a family dispute, and of course there is mistrust, in such a situation as a mediator, how do you prepare for the first session? And additionally, you mentioned that there was a member of their family or a relative who was a mediator, trained mediator as well. How did you come up with that thought to bring them in, and how did that play out? What was the role that they played?
When you do your opening statement and you get the facts on the table, my first endeavor always is to find out if there are third party players who are involved in mediation. We say people who hold actually the key to the gate, and therefore, when I found out that they would require somebody within the family, that who was in our center, who was one of the mediators. So I told them, would you like to involve her also in the matter? And they were agreeable, and lot of pushing and cajoling to bring them on the negotiation table was done by her. So I did not have to really, like, that preparation part was done by this lady. And since they trusted her to that extent, but like she was not able to move them forward, and that's where she needed me. So it's actually, for me, I have found one is as a role as a mediator, and secondly, like in India, co-mediation really works. And we've seen, especially when it's a case of family disputes, where we have gender requirement of a gender balance, and that's where if you have a lady and a man mediating together, co-mediating, it makes all the difference. And this is where this really worked for me, and it helped me. And that preparation stage, I really got help from this girl, and she did a good job in that sense.
It's wonderful. So there are so many multiple facets that we've brought out. We spoke about we've gone the learnings from this mediation. I see like the importance of third party stakeholders, gender balance, co-mediation. I think there are multiple facets which we can always deep dive into and take a do a complete hour, and maybe perhaps in future just have a podcast just on a specific case. Jonathan, do you have any questions regards to this case before we move on to Nadia?
Yeah, I do. So, the Mission Mediation podcast is all about showcasing to India and to the world that mediators are actually mediating, mediation is actually happening. So, JB sir, if you could just tell us how long did it take to finally get to a resolution? And yeah.
Yeah, Jonathan, is basically a back and forth. Unfortunately, almost the main problem, so far as we are concerned, we are all part-time mediators. In India, we still don't have that practice where, the mediation starts in the morning and goes on till the evening. So we would start at 3:30, 4 in the afternoon, and spend maybe 2 hours every session was about 2 hours with them. And so this went on for, I think, about good 4 or 5 months.
Right.
But those 4 or 5 months were very productive, in the sense, like, things which have taken years in court were, because the first instance, like every matter in India, takes maybe 5 years.
And that's the thing, because, sir, you're a senior advocate at the Delhi High Court. So it took 5 months to resolve. But as a lawyer, can you tell me how long that would take if it dragged on in court?
Oh, in the court of first instance, maybe 10 years.
10 years. So we have 10 years versus 5 months if you give mediation a try.
Yes.
All right.
Yes.
We'll rest our case on that then, sir. One quick question, and we'll go to another story. You spoke about the hand holding, if I can call it that, right towards the end. Is that something that clients who participate in mediation, back here, especially in the court and ex mediation context, do they expect the mediator to be hand holding them till like that is signed up, it's executed, or is that a common kind of I would say request that they have of you, or you see that very rarely?
We've been doing that. In some matters, we keep documents in escrow with the center, and those documents are released at each stage. Like, for example, if it was a family dispute where the divorce has to go through, so at the first motion, you'll have certain payments being made. So those payments are deposited already with the center in the form of drafts. So they come back to me and tell me, sir, we have done the first motion, so hand over this draft to the other side. So the draft is handed over. Idea being so that you don't have to fall back on the other party for implementation.
Right.
That's where you have to mold your settlement in a manner that parties feel confident that the settlement will go through.
Yeah, and because you don't want them to be back in court fighting this out back in court once again. So
that the settlement has not has failed in the sense of not implemented fully, and so there's another execution file. We don't want parties to go through that stage again.
Yeah, and that is the mediator's responsibility. We just want to emphasize that, especially for lawyers listening in today to today's podcast. You should be demanding that out of your mediator, to be the person who is waterproofing, who is making sure that settlement agreement is watertight by asking the necessary questions. Sometimes those questions they sound trivial, they sound silly, but they are important, because if you don't ask those questions, then you don't know when, you don't know why, you don't know how, and then you're just happy that there is a settlement, but actually there are no specifics to it. So let's
Jonathan, sometimes, like, they do not really know how it will go through.
Correct.
So these options have to be generated, because since you've been doing mediation, so you have to generate these options and tell them, look, this is the way it can be done. So would you like to go ahead and do this way? Yeah. And so therefore it is important that, because parties really do not know. Yeah. And that's where even mediation advocacy will come in. I feel like here even the advocates should help. I mean, and this is where I realize even sometimes advocates are also, like, in that sense, mediation illiterate. I mean, they may be good advocates in court, but when it comes to mediation, they really do not know how to move forward. So they need to be taught too. The lawyers also need to go through a course on mediation advocacy.
Yeah, we got some fantastic lawyers who are already warming up to it, embracing it, and I'm really looking forward to talk about that as well. Nishant, back to you.
Yes, like I said, we can continue breaking that case down, get more, but that'll need a separate podcast altogether. Nadia, over to you. Which case comes to your mind when which was maybe a memorable one, which maybe was a changing moment, which maybe was challenging? If you could let us know a bit about how the skeletal framework of that mediation was.
Yeah, sure. Quite a few were challenging, but I've thought of one that I think will be interesting and useful. So this was a dispute which involved 3 official parties, legal parties, if you like, and they were all organizations. And there were 13 people eventually who needed to be at the table, not counting their lawyers, right? I guess lawyers for the 3 institutional parties, and each of them had several lawyers. The dispute had been in the relevant courts for about 10 years with lots of interim hearings, and it had been to mediation once before, a year before it ended up coming to me. And I'm not sure if I said this, the legal the legal case was about intellectual property and naming rights. Okay, and these institutions were very well known, and they'd been around for decades and decades and decades, right? But the dispute wasn't necessarily very well known apart from amongst lawyers. So, one of the first things that I thought, of course, is, this is all about IP, and I'm certainly not an IP expert, an intellectual property expert. And I made this very clear. So they came to me via word of mouth, and they had lawyers, and I said, just so that you're clear, I'm not sure what you're expecting from mediation. This is what I can offer you. IP expertise is not what I would offer you. And they went, oh, don't worry about that. We've got hundreds of lawyers who are IP experts. And the clients themselves were fairly sophisticated. And meanwhile, after 10 years, they knew a whole lot about IP anyway. So I said, okay, we can give this a go. So a bit about the process. So I always like, when I can, to design a process. And so I started off, and I spend a lot of time in pre-mediation, and I enjoy that very much. So I spoke either virtually or in person with the lawyers first, and then got their permission to talk to the clients, and spoke to each of these. I spoke to more than 13 people, but the 13 people who ended up being at the table, and that itself took a couple of weeks, right, getting them, and then we agreed to come together. And another part of this thing was, well, how am I going to manage 13 people plus their lawyers? And there are different ways that you can do that, but we eventually agreed that the lawyers would not attend in person, but would be available virtually. They had to fly in from different places, and a couple of people from overseas. So we set aside 3 days over a long weekend, Friday, Saturday, Sunday, and the lawyers were available over that weekend, so there could be consultations and all that sort of thing. And again, I think that worked because of the history of this dispute and who the clients were. And, we talked about mediation advocacy before, and I think this is a really important part of mediation advocacy too, right? Knowing what your role can be, even as an absent advisor in a particular moment. Because remember, this mediation was just a little moment, right, in a dispute that had been articulated and in the courts already for a long time, and had begun when I talked to them decades earlier, actually, right? So, you know, and it was interesting because I thought, okay, if they're at mediation now, they've been to mediation before, and that mediator I happen to know is a very good mediator and happened to be a very good lawyer with expertise in IP. So I had guessed, rightly or wrongly, that they would have focused on IP, right? And if they're now coming to someone who's not doing IP, I guessed that maybe there's something else, right? And that's maybe where I could help them, which ended up being the case. And so we had the people in the room, we had 3 days, we had a great space, which was really important. A law firm had given us their space. On the Friday, we had to be somewhere else. And then we had this law firm. So that meant we had formal settings, informal settings, you know, conference rooms and sofas and coffee tables. And we used all of those spaces that were available to us. And that became really important, right, for putting the people in different groups and getting them to think about the other party's interests. And from memory, we ended up with actually a long list of agenda items, which was longer than I normally would like, something like 14 or something. And the really interesting thing is that one of those issues was about intellectual property. And we ended up dealing with that later in the dispute. And then when we got to that, right, which was later after dealing with other issues, they dealt with that so quickly because they knew everything about IP, much more than I ever will and ever want to. So, you know, that was also, again, a big learning for me. So we had a couple of, for me, interesting features. I think because we knew we'd be there a few days, I'd said, okay, we've got to do lunch, right? So there's a place close by, you know, let's either order beforehand or think about going down. Do we want to go together or separately? And my suggestion to them was, let's go together, but just not talk about the mediation, right? And so we did that. And my idea there was that then they would just connect as people, hopefully, right? And of course, some of that happened, and then they might talk about the mediation, but I didn't really care about that. You know, I wanted them to start connecting. Another interesting thing about this mediation was that 2 of the people, coincidentally, were native German speakers, and I happen to be a German speaker as well. So when we got into a couple of private sessions, and they were upset, you know, when people are angry, right, they often slip into their mother tongue, right? So I had this situation which was unexpected for me, where somehow they knew that I spoke German, and so they would articulate their frustration in German, which I just thought was interesting and a great feature of mediation and something that I hadn't prepared for, but happily engaged in, right? It had nothing to do with their linguistic abilities. They were fabulous, you know, perfect English speakers, but yeah, that I think is an important piece. So on the Saturday afternoon, I think we broke the back of, you know, we could see hope, right? And then we came back Sunday morning and drafted, I guess, some heads of agreement, right? Got all of the lawyers, we warned them that this would hopefully happen, got all the lawyers online, went through it, and then it was their job to turn this into a legal document within the next 7 days or something. So then we sort of stopped, and it was around about lunchtime. And this is the last thing, I know I'm going on a bit, but this is the last thing, which is why this is a memorable mediation. So I know very little about football of any kind, right? Rugby, football, anything with a ball. And it happened to be on this Sunday, a grand final rugby match in this particular jurisdiction. I had no idea. Everybody else in the room knew this, which made me wonder why it settled just in time for the rugby match, right? And so a few of us were still standing around at this draft and putting in some extra suggestions for the lawyers, etc. And there happened to be a bar fridge. So they just helped themselves to the beer in the fridge. I kid you not, you couldn't have scripted this, right? And turned on the big screen in the conference room and started watching this rugby match. And so that was not the end. What we also did in that, because we were talking about shepherding before, you know, following up and holding their hands, because this was such a big thing that was actually about corporate identity and organizational structures and values, and organizations that had over decades demonized one another and the people in them. You know, there was a sort of a lot that they had to do after the mediation as well. And so I suggested, and they agreed to have another meeting 3 months later, right, to see whether the agreement they had needed to be tweaked, right? So we did end up seeing them after the football match again 3 months later for a few tweaks. But for me, there was just a lot of learnings in that. Yeah.
Yes, I think there's just so much to learn. I was just making agenda points. I said, you can just continue breaking this down. But two things that you mentioned that there were 3 legal organizations. It had 13 members, and then of course the lawyers. The dispute was there for 10 years in court, and it was an IP matter. But 2 things that stood out for me was, one, you asked the lawyers for you to be able to speak with the parties privately. So my one of the question will be on that. When you are in your pre-mediation stage and you're wanting to go and you're planning on going for this first meeting with the parties, how do you prepare? What's the mindset? Is there a process, or you just go in and see, okay, let me just understand the facts? And second is, when you are, a lot of people say that, okay, to be a mediator, it is compulsory for you to know the law, right? Now, you mentioned that in this case it was an IP matter, and the understanding of the legal technicalities, you said, was not as much as the parties, right? So how do you deal with that in a situation like this, where hey, that these parties are corporates, they know, and if they feel that you don't understand the law, you don't know, then they might be they might have this hesitation and back out. So how do you deal with that?
Right. I'll deal with the second question because I've already forgotten the first question, so you'll have to ask me that one again.
Sure.
But I think you have credibility for different reasons. Every mediator has a credibility based on different factors, and certainly I don't have a reputation as being a hotshot, fabulous lawyer, right? I have a legal background, but I started my mediation career almost when I just started my career, right, shortly after law school. So somebody needs to have, particularly in a dispute like this, which had been in the courts, somebody needs to have that expertise, right? And so I put it to them, and they said, we have got this expertise in the room in abundance. And what do I need? I need to know enough to ask the right questions, right? Certainly in the style that I mediate, right? And you might go to some, a different type of mediation where for good reasons you might want your mediator to have more subject matter expertise, right? But that would be a different mediator to me. So that's my
did you use the lawyers in this case to get knowledge-based information or subject matter explanation, or did you use the parties, or did you use both?
In this particular case, these people had this big dispute, big conflict, even bigger than a dispute. And intellectual property, that was sort of the way they could voice it, right? That was sort of the label they had to give it. And there was an intellectual property issue, but it was relatively small compared to all of the other things that were underlying it. And in many ways, this is, sort of an ideal case for mediation, because you get to dig underneath, right? And if you'd focused on the legal aspect, that's probably why they were 10 years still in sort of pre-litigation interim hearings and things, because they could never get to what they really wanted to talk about, and maybe they didn't know that themselves properly, right? Or they didn't have that space. I don't know if I'd wanted to, I would have got it from the lawyers, right? But actually, I didn't really need it. Right? When we got to the IP issue, they made their phone calls or whatever they did, and they decided on those issues very quickly, and then we called the lawyers in to go through our heads of agreement, and that took a while. The lawyers were asking questions, and then their job was to turn it into something legally binding, right, in a time frame.
Okay.
Yeah.
I think. It is so what we can say out of it is that it is important process expertise is also important, which is where you can come in. Yes, we had a question from the audience. Jonathan, can you display that question? So the question from one of our viewers, Alexandra: there are times when both parties reach a deadlock and refuse to budge. When you encounter such an impasse, what strategies or techniques would you suggest to lawyers to move the conversation forward and help them find common ground? JP sir, Nadia, over to you. So JP sir, you're on mute.
Ordinarily, whenever something like this happens, I always break the parties into a private session. When I realize that things are not moving, and then I do a little bit of reality testing with lawyers, asking them, look, how would this look if this settlement terms which we are now working on, if we were in court? And or then I take them to, in case if what you're getting or what is on the table, like if you were in court, do you think you would have got it, or is it possible to get this in court? And so a little bit of reality testing helps. Sometimes breaking a session, letting parties go over the whole thing again, sometimes helps. Sometimes we go over whatever has
So,
already
yeah.
happened.
So when you're doing this reality testing, when you mentioned with lawyers, are the parties in the room as well at that point in time?
Usually, when you want the strength of the case to be tested, you don't want parties to be there, because parties always mostly depend on their lawyers, and lawyers give sometimes hopes which may not be realistic. And asking a question, doing a reality testing at that time probably would be showing the lawyer down, and so which you don't want a lawyer to have a face off with the client. And ordinarily we will like to do that with the lawyers separately. And especially when Nadia talked about this, see, when you may not have an expertise of that subject, but you must have the knowledge of the subject. And when you have the knowledge of the subject, the lawyers also will respect you for that. And then when you question them on you do a reality testing, they know where you are taking them. And so they are sometimes truthful. Sometimes they will say, okay, sir, we'll get back to you on this, and then they talk to the clients separately. But issue is, you need to break that session up, because otherwise the impasse means no. And secondly, like sometimes Nishant, what works is going back, recapitulating where we are, where we have traveled, how much distance we've traveled, where we got stuck. And the progress that you have made sometimes makes parties budge from, if they have taken unrealistic positions which cause impasse. So if you can show them the mirror, it works.
So in essence, what we're saying is that we kind of separate the parties into caucus, reality testing, and analyze the progress is what comes from JP. So Nadia, how about you? How do we break an impasse?
Yeah, I always ask myself, what can I change? What can I change about what I'm doing in the process? So that could be, as JP had said, splitting the parties or moving to a different part of the process. Or what can I change about how the parties are relating to each other? I mean, I've had one instance that I remember, mediation, where the two lawyers were really obstructionist. Actually, they didn't like each other at all, right? So I shifted then the seating arrangements. I actually got the parties alone together, and that worked better because that was a block. Or I might think, what can I change about the substance, like how they're talking about the dispute? So if we're talking about money, maybe I'll look at something else like time for payment, or shift their perspective to another substantive point. But I usually sort of just go around those three. What can I change here or here or here, and try that?
So in basically shifting focus maybe on the agenda or onto a different stage of the process, so that there's a bit of diversion there's a bit of diversion, and communication can go on. Jonathan,
yeah, sorry. So I think what even JP sir said about showing them the progress they have made. Sometimes they can't see it. They can't see it because there's so much baggage. They've gone down that rabbit hole of litigation or arbitration, and it's all about winning now. They've invested so much into investigators, into accountants, into all kinds of experts, and they can't see the progress they're making, and they feel they've not moved. But actually, you as a mediator have that vintage point, see the movement they have made. I like that. You show them the progress they've made and say, do you want to continue? Because we're not going backwards, we're going forwards. We're not reached common ground maybe yet. Resolution is still far away, but we are moving forward. And I think I like that about saying that. I think that's one way of really breaking the past. But also with Nadia said this twice, even with her story in the start about. I'm just fascinated, and I know we need to get into the next segment about building practice, but it would be criminal not to dive deep into this. So I think we might not get into the next segment, but I really want to dive deep into this bit that process design. Nadia, you're talking about this, they already had that expertise in IP. They already tried a mediator who was an expert IP practitioner. What they came to you was to say, listen, we know the technicalities of this. We know the facts. We even know the solutions. We're just not able to communicate with each other. We're not able to actually negotiate. And that's what they came to you for, right? That's what I imagine. They came to you to say, listen, help us negotiate. Help us continue this negotiation, which is very interesting, and that that even where you say now, you move the lawyers around, just that design of the process is so crucial to a mediator. I just want to dive deep into that a little bit more. How important is it to a mediator? And if there are any other examples where you can throw out to say that process design, the role of a mediator it cannot be undermined in terms of process design.
I mean, certainly for me, I mean, it depends on the setting in which you're mediating, right? And my very first ever mediation was in a legal aid center where, there was no opportunity for pre-mediation, and somebody said it's about this, but when the duty lawyer said it was about this, and when you went in, it was about something else, right? So sometimes you don't have the opportunity, but where you do have the opportunity for pre-mediation, I think it's crucial, and I think it can, at least in the way I practice, make or break the mediation. And certainly, thinking of another mediation I did, which was a civil liability case involving the death of a couple of people, and there'd been a criminal trial which hadn't resulted in a conviction, and there were some very upset, traumatized, angry families, and they ended up in the civil case, and the matter came to mediation, and I did one of those mediations. There were two. And part of the pre-mediation was, again, going around talking to everybody wherever they were, not necessarily in an office or in their home, or just wherever, in the park, wherever we could meet, and then trying to figure out who needed to be at the table usefully, right? And in this particular case, I'm thinking of, it was a community where both people had mentioned a particular religious figure who was important in their lives, right?
Yeah.
And so I approached him and asked them, what if we ask this person? And they said, yeah, that would be great if he would come. And he did, right? And then we began, for example, with an opening prayer, right, for a civil liability case, right? But it was something which also helped, it was a small design element, but it really helped to set the tone, right, for a very difficult, emotionally difficult mediation.
Yeah. And that's interesting, because in this case, you took the initiative as the mediator to identify that important influencer or a stakeholder. Comparing to what JP Sir shared during his case study, where it was the influencer, if you would like to call it, or the stakeholder, or someone who was familiar with both sides, was able to bring JP Singh in as a mediator. So it's interesting. It's an interesting dynamic where here you as a mediator identify that person who can help them connect. Whereas in your story, sir, the connection was the person who brought you in to kind of facilitate. So we can never undermine. Nadia, you want to say something on that?
No, I was just going to say, I mean, it also to me speaks to the fact that as mediators in any given mediation, we bring a different bundle of characteristics or qualities to the table, right? We could be an insider mediator or an outsider mediator or a bit of both, and where you have the availability of a trusted person that could be within the mediator, right? Or it could be elsewhere. And I think it's really helpful when, in pre-mediation, not to sort of, to let go of assumptions and just think, what influences do I need in whatever form they may come?
Yeah, absolutely. And for all of you joining us still live on LinkedIn and YouTube, drop in those comments. Tell us what you feel about what's being discussed. You might not agree with us. Don't worry about the Indian Mediation Act right now. Keep it to the side. The statute will take care of itself. We've got a fantastic team working on this. The Mediation Council of India will figure out. Let's focus on JP Sir's and Nadia's stories today. The process design of mediation. Leave the procedures out of this for the next 15 minutes. Let's dive deep into this. I want to go to another bit here. I've always said mediation allows you to look at the people beyond the problem. Now, there's a problem which is always in focus in litigation or arbitration. Mediation allows you to go to the people. And in the story that both of you shared, there was you as mediators help them connect as people, which sometimes is gone astray. Whether it's commercial, in the case that you shared with us, Nadia, or whether it's a family dispute that JP shared, there is that loss in connection. And whether it's watching a rugby match and de-stressing out there, or whether it's just connecting as people, the mediator plays that very, very important role once again to build that connection again, just as people, just as humans, to know that there is a problem, and the problem is almost like a third entity out there. If you want to give it a personality, but there are people, and So, JP, sir, any stories from your side in terms of how you kind of help them connect as people?
Jonathan, I've seen this in action in every mediation that I do.
Yeah.
The manner in which you should see the body language of parties when they appear in mediation. And as the process moves on, how they relax and start talking to each other. The initial communication is always through the mediator. They don't even look at each other. And then suddenly you find after a few sessions, they are relaxed. They may not agree. They go on saying, look, I was also saying something like this, you would not listen to me. Why don't we try this? And this communication is directly happening. And there's a matter which I'm doing. This property needs to be divided. So they are not very clear on, because there are several gift deeds and other wills, etc., etc. So the share in the dispute, there are two siblings, but they are all claiming, somebody claims 75% share in the property because of the gift deed executed by the grandfather, or somebody says because of the will of the mother. So I'm entitled to 65% share. But what I saw, after discussing all this, with the lawyers, sometimes you have a private session with the lawyers, make them do reality testing. See, sometimes, as I said, lawyers themselves are not able to generate options. And therefore, you actually assist them into looking at certain options and say, look, would you like to look at something like this? And this is where, so after that, when the parties were brought in, we were told, that we were standing outside, we started talking to each other. And I'm telling you, it was such a heartening experience. They sat across the table and I was just mute spectator. And I was seeing both of them talking, the one saying, look, I've always been saying this, we should sit across the table and finish this instead of spending years in court. And the other side saying, look, I need time to consider on what you are saying. All this was happening directly. So what you do essentially, when we talk of self-determination or right of you empower parties so that they start looking at the problems themselves. You don't have to assist them.
Yeah. But JP sir, and I think even Nadia will agree with this, there are a lot of mediators who feel, what's the word for it? They feel unpurposeful when they feel they're not really contributing enough as a mediator. It's like, listen, it's almost like they want to be part of it, and how, because in training, when we're trained as mediators, I don't know how much time we spend on this, what's your purpose as a mediator? Because a lot of mediators are uncomfortable with parties self-determining. We like talking about it as a principle. But when parties are tending to get, involved on their own, we feel like there's no purpose, there's no value for us as mediators. I'm touching on some very sensitive topics here. But that's the truth of the matter for a lot of mediators who especially mediate in court and ex mediations in, I would say, context. Yeah. Do you want to respond to what I just said?
Jonathan, I would love to sit there, just observe parties talk, except that, if they are going off somewhere, I'll bring them back to it. That's all that I observe as my role. Otherwise, I enjoy when the parties, get into a communication themselves. Because, this process has a dynamics of its own. You don't really have to do anything. If you have set it into motion, it will bring results. Parties dispute, parties will find solutions. You really don't need to do anything.
Not always. I'm sure Nadia's got a response to that as well.
Shall I jump in? Okay. So your question was about conflict, and I always think conflict happens between people. Conflict's not on the paper, all right? So it's really about getting in and dealing with who those people are. And then Jonathan, you made a comment, that mediators want to be part of it, and then and sometimes they're thinking, well, what can I do to be part of it? And then my question is, well, what is it? Right. And that begs the question, what is it, and what is the goal of the mediation? And I think one of the really interesting things is, which is why, again, I love pre-mediation, is that you can have a situation where every single person at the table, including the mediator, will have a different idea about what the goal of this mediation is. Right. And that also then influences how you mediate. Is it just to settle the legal issues? Right. Is it about what's important for the parties and working out something sensible for them in terms of their interests? Is it about values and identity, right? Is it about shifting a relationship so they, as JP was suggesting, they can then go on and sort this dispute out and others? And I think a really important conversation is, what's the goal of this mediation? For every person, the lawyers may also have a very different goal in the moment of that mediation as well.
Interesting. I think defining that the goal is crucial, defining purpose as well. Nishant, I know you have something on your mind.
Absolutely. I think I have time on my mind at the moment. I know Naz going to be has other commitments as well. So I think we'll jump into a last segment, and that's to understand how we can build our practices as mediators or mediation lawyers, because Nadia and JP sir, both of you all have made a conscious decision and effort to base a majority of your career on mediation, as both of you have been lawyers, but people now, JP sir still practice, but people associate him with mediation. When we talk about mediators in India, his name is always there. Nadia, whether it is practicing mediation or even the academics. So how is it that you built your practice, and how can we sustain, as young lawyers at 25 or 30 who are saying, okay, we want to get into mediation? How do they do that? JP sir, starting with you maybe.
Nishant, first important thing is 40-hour training merely introduces you to the concept. So we need to understand that you need to first of all get quality training. And most important part, I think, if you need to build up mediation practice, is passion. If you are really not passionate about the whole concept and the subject, and so yes, money will follow you. I mean, in the sense when we took up mediation, it was basically more of a challenge, because bar was up in arms, and being the vice president, when the Chief Justice told us that I want to start this movement, so it was a big challenge. And so we hid and did our first training, because we didn't want the bar to know that we were doing actually mediation training. And then we came back and told the bar, well, it's something great that you need to look at. Because, as was in other countries, basically, it was perceived as an alarming drop in revenue, the ADR. So, but my take would be, first, you must have passion if you really want to do it. Secondly, get quality training. And then thereafter, what is important is you must, because that 40-hour training is not good enough. I mean, I always tell people, you may do as many trainings as possible, whoever is giving it to you, because there's always some value you will add to what are the skills that you know. So you need to hone up your skills, because later on, as an advocate also, people don't come to you immediately. I mean, your reputation travels. So you have to really mediate thereafter, which means you must join an organization where it is possible to do actual mediations. Your reputation will travel. And today, let me tell you, I mean, yes, professionally in India right now, I mean, Delhi High Court may be paying the maximum to a mediator when it comes to court annex mediation centers. But in private mediation, I mean, I've been asked to conciliate some matters, and where people have paid me very well. And let me tell you, settlements that have been happening, it's not just family disputes. Settlements running into crores, 123 crores was a settlement in a conciliation which I did, and the Delhi High Court, the highest, the settlement which has happened is 758 crores. So there is money in the profession. Question is, you have to have the passion to stick on with it. Even in the, that even in our, the advocates profession, the initial years are tough.
Yeah.
It's only once your name starts circulating, you start getting work, you've done work, you get relief to clients, people come to you. Similarly, in mediation, it'll take time.
So for you, the passion, the training, and the practice is what has kept you going. Nadia, how about you? How was it for you to build that and market yourself as a mediation professional?
So you talked about being 25 and wanting to move in, and I also was around that age, or even possibly a tiny bit younger, when I decided, okay, this is what I want to do. And it was at a time that even then it was in Australia, early to mid 1990s, and there was still a lot of people trying to get experience, right? There was still that issue. And I am not today, and never have been, a full-time mediator. I'm a full-time mediation professional, and I love this role I have, right? I love it. I mean, I've worked in different institutions and also completely individually without an institution, in periods of my life, but I've always had this combination of roles around mediation. And I think, my power back then, right? I'd worked for a short amount of time as a lawyer, and then I'd worked for a short amount of time as a management consultant, and I didn't like any of that. And anyway, then, always by an accident, you discover this thing called mediation. And at the time, no one wanted to touch it. And my well-meaning colleagues said, don't do it. It's going to ruin your career. Just don't do it. But, my power was that I had nothing to lose. Do you know what I mean? I didn't have, any career to speak of at the time. And I was really passionate about it, to take JP's words, right? And I think all of us here are, and probably everybody listening. So, for me, it was doing what I can, right? Yes, doing the trainings, doing whatever mediations I could, but also facilitating meetings wherever I could. And I did, also in the early days, quite a few what would be called today deal mediations. Went into strategy meetings of organizations who were talking about a joint venture and facilitated those, which today you would call deal mediation, right? And then also got involved in design and policy. And obviously teaching and writing. And for me, the beauty, this is why I'm still so jazzed and excited about what I do, is that all of these aspects in mediation influence one another, right? My writing helps my practice helps my teaching, and if I'm thinking about policy or reviewing a piece of mediation legislation, the fact that I can practice and have thought about things a lot helps or influences that, and I enjoy that. And so I would say to everybody, think broadly. And also, a lot of the mediations I would get don't come from lawyers, but come from, for example, HR, right? From within an organization, right? And there may not be lawyers involved at all because it hasn't got there yet. So I need to stop because I think our time is up. But think broadly would be my piece, and stick to it.
Interesting. So you've mentioned passion, of course, as JP sir mentioned, and doing whatever it is that you can, whether it's writing, whether it's reading, whether it is being a part of strategy meetings. Yeah, you rightly said you don't need to wait for a mediation to come, but you can be a part of negotiations between different departments, between employees and different entities. So yes, I think that is a must to take forward from this. It was a wonderful session. Jonathan, over to you for the closing.
I'll actually hand it to JP sir and Nadia for closing 20 seconds of the last comments. But before that, I just want to say that I like what Nadia said about look at yourself as a mediation professional rather than a mediator. I like that because then you're looking at this very holistically from an all-round perspective to kind of build your career out there. This has been fantastic. We started out by talking about stakeholder involvement, appreciating everyone involved, bring in the right people to help you build that connect between two parties who are struggling to negotiate. That you as a mediator play a very, very crucial role. And sometimes your role is different. Sometimes you are expected to help them with a few suggestions and a few ideas, but sometimes they already know all that, and all that they require from you is to help them communicate that to each other, which they're really, really struggling. And let's not take that role for granted. Sometimes we feel that we feel that role is very trivial. That's actually what they want. They don't want anything else. They already know everything else. So I think this has been really fascinating and really insightful. So thank you so much. We got loads of notes out here. But JP sir and Nadia, final thoughts on, I would say, just to everyone who's watching in, a lawyer, a mediator, every other stakeholder, a user, a business person, what's your message going out to them in terms of embracing mediation in commercial or personal disputes? Quick message.
See, so far as I see mediation is here to stay. Let's understand that mediation is here to stay. And you have the Mediation Act. There you have several statutes now bringing in mediation. So therefore, this is in future going to become an alternate profession so far as lawyers and even non-lawyers are concerned. Don't have to be a lawyer merely just because you want to be a mediator. You don't have to be a lawyer. And so therefore, this is what I see is a lot of future in it. And remember this thing, when so far as courts are concerned, courts are basically concerned in having dockets off their back because of so many matters pending in court. And so therefore, they looked at it as I said, a mode where disputes can be settled and taken off the roster. But let me tell you, there are a lot of conflicts which really never reach the court. And this is where a mediator's role comes in. And so therefore, whether it's community mediation, like, we are now looking at peer mediation. We have been going to law colleges where we are looking at, telling law students as what is the future of mediation, as compared to adversarial setup that we are so used to. And so I think the future lies in really looking at what community service that you can do, like how you can get rid of conflicts. And see, you live in that conflict-ridden society. Conflicts are part of life. Question is, a lot of us really do not know how to deal with those conflicts. And mediation training is not about settling matters, is about dealing with conflicts and dealing with, and these are skills which you need to deal with your siblings. You need these skills to deal with your superiors. These skills are required to how you deal with your friends. So therefore, let's look at mediation as something which you need as an overall personality development. And it's just not about settling disputes in courts.
Thanks, JP sir. Nadia, over to you.
I love what you said, JP. It made me think of, mediators don't need to be good at harmony. They need to be good at conflict, right? They need to be able to go to the heat. And I think people often forget that. I think right now it's a fabulous time to get involved in mediation or sort of make some moves in mediation, because more than ever before we've got regulatory structures, institutional structures. We've got fabulous training opportunities through AI and technology. We can reach mediators, reach resources all over the world. We have a United Nations Treaty, the Singapore Convention. So a lot of eyes are on mediation, and that means a lot of opportunity. Where do you start? Anywhere you can and everywhere you can, I would say. Yeah. And good luck.
Thank you, Nadia. I like that. Mediators is not about, your focus is not on resolution, but on conflict. Be ready to go there. I like that. And JP so, of course, once again talking about the fact that it's not just what comes out of courtrooms and what's referred by the judges, but there's place for a mediator beyond that. This has been fantastic. Nadia, thank you so much for joining us on a Saturday evening from Australia. JP so on a very busy Saturday afternoon from Delhi in India. And Nishant, thank you so much for being my co-host and partner for the last 10 years at the Pact. We're going to keep this going in the Mission Mediation podcast. Thank you, everyone who joined us live, and for those who are going to watch this on record. This has been the Mission Mediation podcast. We're going to catch you on the next one in a fortnight. Until then, see you. Bye.
Thank you. Bye-bye. Thank you.
Thank you.